Let's see, that's CMAC. Okay, if I could have you both on mute, please. And we'll go on the record in CMAC versus CMAC. This is file number 125-14799. The record should reflect that both parties are present today by Zoom video. This is set for a status conference today. Looks like the last time we met was back in August, and the court referred this to mediation. So I'll start with Mr. CMAC as the plaintiff. Did you participate in mediation? Were you guys able to reach any agreements?
Yes, we did participate, and no, we did not make an agreement in mediation.
Okay, from your side of things, what are the issues that are causing the problem here?
The issues are stating that I owe her $14,177.16, where she stated that I used her bank account without her consent, which is untrue. I did get her consent from every purchase on that, because I did ask on every one of those. And she also stated that I barely worked for many months because I wasn't licensed, which is also untrue. I was working, doing odds and end jobs that didn't require a license. Therefore, that way I could pay for my mortgage, electric bills, gas, food.
Okay. All right. I don't need to go into all the details. I just need to find out like what the issues are that I'm going to have to decide here. So it sounds like that money is there from your standpoint, and I'll ask you in a second, Ms. CMAC. Mr. CMAC, are there any other issues from your standpoint?
No.
Okay. All right, Ms. CMAC, how about you? What do you think these sticking points are here?
Sticking points is that he said he got permission to use my card and he did not. Everything that I am asking to be reimbursed for is pertaining to his business. I did not say he did not work. He did work, but he wasn't licensed. We couldn't do licensed work. And the time that he used my card was the entire time that he was not licensed. So he was buying his supplies to start up his business, to keep himself afloat, buying supplies for homes, and he would get paid for those and never reimburse me for them. And so I want that money back.
Okay. All right. So what I'm going to do is set this for a hearing date. That's when both of you will come here in person, and you'll both need to bring whatever documentation you have or whatever witnesses you have, because that's going to be the day for me to take evidence. So you can both testify, but if you have any documentary evidence, you'll need to bring that as well. And then I'll have to make a decision about whether and to what extent, either of you should pay the other any amounts of money, and then we'll finalize things. Mr. CMAC, do you have any questions about that?
No, sir.
Ms. CMAC, do you have any questions?
Nope.
Okay, all right. So I will set that for a 2-hour hearing. I think that should be enough time. You'll both get notice of the date and time of that hearing. Again, that will be in person. So that'll be here at the courthouse in Kalkaska. And we'll go forward at that time. If neither of you has any additional questions, then that's all we have for today, and you're both free to disconnect.
Thank you, sir.
Just whatever the thinnest part of that is.
This is the thinnest part. Oh, is there? Oh, yep, there sure is. Sorry.
That's better. I just need something with all the lawyers on it. So I can see who.
I know it was thin, so I was like, maybe I should bring both of them just in case.
You never know.
That's true. So many giant files.
Okay, looks like we've got everybody connected, so we'll go on the record. This is Antaya versus Schulich et al. This is file number 2213998. And if I can just have counsel put your appearances on, starting with plaintiff.
Emily Peacock for the plaintiff.
Nick Artev on behalf of the Munson defendants.
Justin Hackler for Dr. Szyminski, Your Honor. Good afternoon.
Camille Lewis on behalf of Dr. Craven, Matthew Schulich, and Kalkaska Memorial Health Center.
And Connor Morgan on behalf of Sound Inpatient Physicians, Danette Wells, PA, and Elizabeth Hunter, DO.
Okay, all right. We're on the record today for purposes of a status conference. And so, Ms. Peacock, I'll just start with you from plaintiff's side. Where are things at right now, and what do we need to do for scheduling?
Thanks, Judge. I would just say that we are continuing with expert discovery, but we should probably work on getting this set for trial. Ms. Matson's office is always very busy, as is Mr. Hakla and Mr. Morgan. And Mr. Artave's office too, but the Munson defendants will likely, we've worked out a deal with them, so, or we're working on it.
Okay, from your standpoint as plaintiff, like what kind of time frame are you looking at for the court to set the trial dates, and then how many days of trial do you think would need to be set aside?
I would say the entire trial would take at least 2 weeks. And I would just ask that the court set a date in its schedule that we know can go forward and works with everybody's schedule, because it's very expensive to line up experts and have them come in.
Yeah, okay. All right, Mr. Arteev, what's your view on this?
I don't really have a view, Your Honor. Like Ms. Peacock indicated, we've worked out a deal with our clients, so we hope to have a dismissal order entered for our clients specifically soon.
Okay. Okay, so you guys won't be part of it anymore. Munson will be out. Okay, Mr. Hakala.
I think I'm on the same page as Ms. Peacock. Once we get done with experts, I think we're ready to get a trial date, and I totally concur with the idea of setting something that's a solid date for everybody, because it's an enormous headache, as you know, Judge. So I'm on the same page.
Okay, all right. Ms. Lewis.
I don't really have anything to add. I'd say I'm also on the same page as everyone else.
All right, Mr. Morgan.
Same here, Your Honor. Not much to add. Agree with all of that. Get my trial schedule up here to give you some times we aren't available to, in the event we try to pick out a date now.
Okay, well, I can't do a date now, but what I can tell you, if we're going to need 2 complete weeks, it's going to have to be set sometime fairly far into the future, primarily because, as you may be aware, I'm in a 3-county circuit, and I only have 1 week per month in each county for my trial week, which means I have to borrow another trial week from my fellow circuit judge, and sometimes that takes a little bit of doing. So I would anticipate that the trial date would be sometime in late winter, early spring of 2026. So, probably within about 6 months would be my guess. And I think that looking at that as a time frame, that should be enough time for everybody to adjust schedules and so forth. I mean, that's setting that far enough out in advance. But I don't think that should be an issue. To the extent it is, obviously we'll work with counsel to make sure that we have dates that are going to, you know, that aren't going to have to be moved because of scheduling conflicts. I mean, I would hazard a guess, it's certainly possible, but this case is old. It's from 2022. So I'm going to hazard a guess that most of you don't have cases that are older than this, that, you know, I wouldn't be able, to the extent you have conflicting trial schedules, that I wouldn't be able to argue to another judge in a different circuit that this one should have priority given the age. So again, I think to the extent there are conflicts, and the way that how far we're setting this out, we should be able to have firm trial dates. And then what I do is set this for what I call a trial preparation conference, about a month, sometimes 6 weeks prior to the trial date, where, and given the number of attorneys, I'll probably set that as an in-person hearing. It's just easier to manage that way, as opposed to everybody taking turns over video. Where we will all sit down, we'll talk about kind of all the procedural aspects of the trial, you know, the composition of the jury, jury instructions, verdict forms, use of courtroom technology, exchange of final witness and exhibit lists, and so forth. All of those are things that we'll sit down and hammer out as part of that trial prep conference. I schedule it far enough in advance of trial that everybody can make adjustments to the extent that they need to. And then in my scheduling order, I'll also indicate that if there are any motions, that they would need to be filed and set for hearing no later than the date of that final trial prep conference, so that we can address any issues that would need to happen by motion, so that when we do get to the trial, it's a matter of jury selection and going right into the case. We're not wasting trial time dealing with motions and legal issues. So that would be my proposal for going forward. And I would put all of that I've just indicated to you into a scheduling order reflecting that we've discussed it today. And then we would send out from my office trial dates and the date of that final trial preparation conference. And I think that would give us a framework for going forward, that we'll have a trial date out there that everybody can work backwards from in terms of your discovery and so forth. And hopefully a final resolution of the case. So Ms. Peacock, all that being said, do you have any objection to doing that going forward, or anything that you would like me to change in terms of that, what I've stated?
That all sounds good, Judge. I would say that now that significant expert discovery has occurred, including this morning, I was just wondering if you wanted to order the matter back to facilitation.
I mean, if that's something that, it's not something that I would necessarily order at this point. The parties want to participate in that. You're more than welcome to do that. I don't know. I don't know what defense counsel thinks. Ms. Peacock, is that something from your standpoint that you think would be helpful or result in a possible settlement at this point?
Well, it is a date and time set to talk about settlement, and lawyers usually do better with deadlines, but you know, if the defendants are not interested, that's okay too. I just thought I would throw it out there. They did agree with everything I said the first time, so you never know.
Okay, outside of the facilitation part of it, you don't have an objection to anything else that I've discussed in terms of going forward?
No, that sounds perfect, Your Honor.
Okay, Mr. Hackala.
Same for me, Judge. The only case I have that is as old as this one going to trial in the winter or spring of 2026 is before you in Crawford County. So double book it as far as I'm concerned. I'll be there.
Okay, how about the participating in further mediation?
No objection to that, Judge. We've talked a little bit between counsel, between plaintiff's counsel and myself, and I'm totally willing to pick up the phone, but there's no question that sometimes a hard date makes it easier for bureaucratic institutions to make decisions, including sometimes defense counsel. So.
Okay. All right, sounds good. Thank you. Ms. Lewis?
I'm fine with everything going forward, and I think my office would also be amenable to going back to facilitation as well.
Okay, and Mr. Morgan?
As far as the schedule, that all sounds great. The facilitation, we still haven't deposed plaintiff's PA, standard of care expert. So I don't want to speak for my boss, Rich, who would ultimately try the case, but I think we'd probably want to depose plaintiff's PA expert before we go back to facilitation. Just so we can get a better understanding of the exact standard of care criticisms as to one of our clients.
Okay. Okay, so we're going to go forward with everything I've indicated. I'm going to add into that, just based on what you've all said. The court is going to order the parties to participate in one more round of mediation, with that to occur by February 1st of 26. So that should give enough time to complete any additional discovery. Obviously, you can schedule at any time prior to that, but the deadline will be by February 1st. And then that will also allow everybody in the court to take down those trial dates if there's a resolution within a period of time where I can use those dates for something else. So again, I'll put that all into an order that'll go out to the parties. Ms. Peacock, anything else I can address for your side today?
No, thank you, Judge.
Mr. Hackala?
Thank you for your time, Judge. All set.
Okay. Ms. Lewis?
Nothing from me. Thank you.
Mr. Morgan?
No, Your Honor, thank you very much.
Okay, that's all for today. Everybody's free to disconnect. Thank you.
Thank you.
See the next one. Okay, can you guys unmute there?
There we go.
All right, thank you. Are you Holly and Brandon?
We are.
Okay, great, thank you. All right, so we're on the record now in forward versus forward. This is file number 2514846. The record should reflect both parties are present today by Zoom video. I have this set for a hearing in this divorce case. Looking at the file here, it looks like there was a proposed judgment that was submitted by you, Miss Forward. Did you want to go forward with finalizing the divorce today?
Yes.
Okay, and Mr. Forward, I see that Miss Forward has signed this. Have you looked at this proposed judgment that was submitted to the court?
Yes, we went through it together.
You did, okay. And did you also want to proceed with finalizing things today?
Yes.
Okay, all right. So I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both please raise your right hands. You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hands. Ms. Forward, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the proposed judgment and in your complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and that there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this proposed judgment, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And the judgment of divorce contains some addendums, and those describe how certain personal property is going to be divided up, how some real property is going to be divided up, and some vehicles. And you've signed that judgment. In signing that judgment, does that indicate your willingness to abide by the terms of that property division?
Yes.
Okay, and you're asking to have your last name changed, is that correct?
Yes. Back to my maiden name.
Okay. All right, thank you. Mr. Forward, did you hear all the questions that I asked Ms. Forward?
Yes.
Were you able to hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
Under this judgment of divorce, you also would not be receiving any alimony or spousal support. You also would not be able to come back later and ask the court for that. Do you understand that?
Yes.
Okay, and you indicated that even though you haven't signed this judgment, that you did go through it with Ms. Forward and that you're agreeing to divide up all those items of property as indicated in that judgment?
Yes.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the proposed judgment. The court finds that it's equitable and contains all the provisions required by statute. So I'm signing that judgment with today's date. That means your divorce is final as of today. Ms. Forward, what that means is that your name will be legally changed from today going forward. So you'll need to make sure that you change your identification and other documents, okay?
Okay.
Ms. Forward, did you have any questions for me at all?
I think I need a copy of the papers in order, or the judgment to change my name. How do I get those?
You can call the clerk's office here in Kalkaska and they can help you get a copy of that for your records.
Okay, thank you.
Mr. Forward, did you have any questions?
No.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Okay, thank you.
Looking for that. And, yeah. Oh, who are we doing now?
I have the Berg one.
Oh, Bert, I'm sorry. Oh, you've got it. Sorry.
Sir, can you unmute for me, please?
Yes, sir.
Hi, can you tell me your name?
Ian Berg.
Okay, Mr. Berg, all right. And Miss Berg, are you there also?
Yes, I am.
Okay. All right, so we're on the record in Berg versus Berg, and this is file number 2113761. And this is a continuation of a hearing, I think, that we had last month in September.
Correct.
So Miss Berg, can you tell me what's happened over the past month from your
Well,
standpoint?
I finally got a hold of Brian, and he's going to let me find the real estate agent, and we're going to get along, because he was always calling names and, you know, making it hard to communicate. So I texted him yesterday, I think it was, and he's agreed to get along and go with the judgment, which is the only thing that I'm responsible for is to help pay my half of property taxes and like house insurance. And
Okay.
he was always telling me I'm responsible for other stuff, which I'm not.
Okay, in terms of getting the house taken care of, Mr. Berg, is that correct? Do you believe you're going to be able to cooperate with Ms. Berg to get that taken care of?
Yes, sir, I do.
Okay.
Like she said, we texted yesterday and agreed to relist it. So
Okay. All right, so we'll go forward with that plan. I'm not going to schedule any future hearings, Ms. Berg or Mr. Berg. If problems arise, then either of you should file something with the court, but otherwise, I'm not going to schedule anything further. Ms. Berg, do you have any questions at all?
Nope, I just wanted to like review the judgment to Brian without him getting upset or getting angry with me.
Okay. All right, Mr. Berg, do you have any questions?
no, sir, I do not.
Okay, thank you. That's all for today. Both sides are free to disconnect at this time.
Thank you.
Thank you.
All right, ma'am, can you unmute for me? Hi there, can you tell me your name, please?
Yes, sir. Kimberly Nestle.
Okay, and everything's sideways there. I can't see the gentleman there. Can you tell me his name, or can you tell me your name, sir?
David Nestle.
Oh, okay. All right. Thank you. All right, so we're on the record here. This is file number 2514843, Nestle versus Nestle. And okay, I have this set for entry of a judgment of divorce today. Ms. Nestle, is that how you wanted to proceed?
Yes, Your Honor.
And Mr. Nestle, is that how you wanted to go forward as well?
Yes, sir.
Okay. Can I have both of you raise your right hands, please? Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Okay, thank you. All right, I'm going to be asking you both some questions. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Nestle, you filed the complaint for divorce in this case, and you signed that complaint. Is that true?
Yes, Your Honor.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, Your Honor.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, Your Honor.
Does that remain true today?
Yes, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, Your Honor.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back and ask the court for that later.
Yes, Your Honor.
And have you and Mr. Nestle already divided up all the assets and debts of the marriage between the two of you?
Yes, Your Honor.
And do you own any real estate or real property together?
Vehicles? No, Your Honor.
Okay. All right. Mr. Nestle, did you hear all the questions that I asked Ms. Nestle?
Yes, Your Honor.
Did you hear all of her answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers she gave were untrue?
No, Your Honor.
Under the judgment, you also would not be receiving any alimony or spousal support. You understand that you would also be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
Okay. Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I signed that judgment. Ms. Nestle, you're asking to have your last name changed. Is that correct?
Yes, Your Honor, but not immediately.
Okay, then I'm going to, that's written in this judgment. If it stays in the judgment, it'll happen immediately. So would you like me to cross that part out then?
Yes, Your Honor.
Okay. Okay, so I'm writing that in, no name change at this time.
Thank you, sir.
Okay, otherwise your divorce is final as of today. Ms. Nestle, do you have any questions at all?
No, Your Honor.
Mr. Nestle, did you have any questions?
No, sir.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you, Your Honor.
Okay, let's see. Mr. Blumberg, is Mr. Castro there with you?
Yes, he is, Judge. He certainly is.
Oh, okay, great. Okay, so we'll go on the record. This is Castro versus Castro, file number 25-14850. If I could have both counsel put your appearances on, please.
Good afternoon, Your Honor. Elliot Blumberg on behalf of Eduardo Castro, who's appearing via Zoom.
Good afternoon, Your Honor. Angel Kaylee Anderson on behalf of Christy Castro, who is also appearing via Zoom independently.
All right, we're set for a status conference in this case today. I thought I saw maybe a proposed judgment go across my desk earlier this week, but maybe not. Mr. Blumberg, do we have a resolution of this file?
Yes, and we did have a consent judgment executed by the parties. Is it not in the court file or somewhere over there?
It's not in the file, but like I said, I may have accidentally left that in Gaylord, but I did see that. So I do have a copy of it.
Your Honor, those were also filed with the clerk's office in Kalkaska. So Mr. Blumberg's office emailed it to your scheduling clerk and I took them, so they are there somewhere.
Okay, all right, so that's good. I'll be able to sign the judgment, but if both parties are ready to proceed, I can place your clients under oath and we can take proofs. So Mr. and Ms. Castro, I'm gonna need you to unmute. And if you can both raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes. Thank you. All right, Mr. Blumberg, if you'd like to proceed first with your client as the plaintiff in this case.
Thank you. Eduardo, would you state your full name for the record, please?
Eduardo Castro.
And you are the plaintiff in this action, is that correct?
Correct.
Is it true that on July 23 of 2025, you filed a complaint for divorce in Kalkaska County?
Correct.
And at that time, you alleged that on November 9th of 2019, you were married to Christy Castro in Kalkaska County, Michigan.
Correct.
And that ceremony was performed by an individual who was authorized to perform marriages?
Yes.
In your complaint, you further alleged that you had been a resident of the state of Michigan for at least 180 days immediately preceding the filing of your complaint. Was that true?
Yes.
And you alleged that you had been a resident of Kalkaska County for at least 10 days immediately preceding the filing. Is that also true?
Yes.
There were no children born in this marriage. Is that correct?
Correct.
In your complaint, you alleged that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed this complaint?
That's correct.
Is that true today?
Yes.
Now, you and Ms. Castro do not own any real estate together. Is that correct?
Correct.
And my understanding is you've already divided up all of the personal property of the marriage. Is that true?
Yes.
And in fact, there was a joint account in which she's taken actually a bit more than 50% of the proceeds. Is that right?
Yeah.
Okay. And again, you're okay with that? You believe that to be both fair and equitable?
Correct.
Now, do you understand that neither you nor she has petitioned this court for spousal support, and neither of you are going to be able to come back at a later date and ask the court to revisit that issue? Spousal support is forever barred. Do you understand that?
Yes.
Okay. Now, you and she have come to an agreement. It's now been incorporated into this proposed judgment of divorce. Do you believe that the division of the assets of this marriage are both fair and equitable?
Yes.
Okay. And again, you've already indicated that to your knowledge, your wife is not currently pregnant.
Correct.
Okay. If for whatever reason Judge Mertz did not sign this proposed judgment, is there any likelihood that the two of you could go back to living together as husband and wife?
No.
Are you asking the judge to ultimately sign this judgment of divorce?
Yes.
Thank you. I have no other questions, Your Honor.
All right, thank you. Mr. Castro used to work for the Otsego County court system, is that correct?
Yes.
Okay, I just want to make sure, Ms. Anderson, I'm assuming that you knew that and that your client was aware of that, but I want to make sure that I disclose that for the record. I didn't work directly with Mr. Castro So I don't feel that I have a reason to disqualify, particularly as the parties have reached an agreement. I'm not going to be called on to make any decisions. But I want to make sure I disclose that for the record. Ms. Anderson, did you have any questions either for me about that or for Mr. Castro in terms of his testimony?
Thank you for that disclosure, Your Honor. We were aware of that and had no concerns, and were trusted that if you had concerns, you would bring them up as you have. And I have no questions for Mr. Castro.
Did you wish to take any testimony from your client today?
Yes, Your Honor. Ms. Castro, did you hear the testimony from Mr. Castro?
Yes.
Do you agree? Do you agree with what he's testified to?
The only thing I disagree with, which it doesn't really matter because like everything's divided and set, just he said that I took more than half of what was in the joint accounts, and that's not true. I took less than half, but like I said, it doesn't really, matter much because it's all divided, so all good.
But you agree with the statutory requirements that he lived in the state of Michigan, within the
Yes.
county, and that there's been a breakdown in the marriage?
Yes. Yeah.
Okay. Are you currently pregnant?
No.
Okay. And you did not request spousal support in this case. Do you understand that that is now forever barred and can never be revisited?
Yes.
And would you like the court to restore your name to Christy Leebrook Leetow, or is it Lightow?
Lido. Yes.
Lido,
Thank you.
sorry. And that's what you'd like your name restored to?
Yes.
And you've gone through this judgment of divorce and you signed it willingly and freely, and you agree that it's, can you say your answer, please?
Yes.
Okay. And you agree that it's an equitable resolution to your divorce?
Yes.
Thank you.
Mr. Blumberg, did you have any questions for Ms. Castro?
I did not, Judge.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce and will sign that judgment. I may not be able to sign it today, but it'll be signed by tomorrow at the latest. And I'm sure counsel's made arrangements to get copies of that once it's signed. Mr. Blumberg, anything further that I can address for your side today?
No, Judge, thank you.
Ms. Anderson, anything further from your side?
No, thank you.
Okay, thank you. That's all for today. And all parties on this case are free to disconnect at this time.
I'll run over and check for that.
Yeah, if we have it.
I remember Angel coming in.
Mr. Isles, are you signing in on the Ernst case?
Yes, Your Honor. I filed my appearance this morning about 9 o'clock.
Okay, great. Okay, so we'll go on the record in Ernst versus Ernst. This is file number 2514810. If I can just have both counsel put your appearances on for the record, starting with plaintiff.
Your Honor, my name is Craig W. Elhart. I appear today on behalf of Clara Ernst, who also appears with me.
Scott Isles, behalf of Nick Ernst, who is zoomed in.
Thank you. On behalf of plaintiff, Mr. Elhart, this is set for a status conference today. Can you tell me where we're at with this file?
Yes, Your Honor. The parties have resolved their differences. We've executed a judgment that was drafted by Mr. Isles prior to his formal appearance, and that has been sent to the court. I'd ask to put on pro confessor proofs today and allow the matter to be resolved in that fashion.
Thank you. Mr. Isles, do you have any objection to that?
I have no objection to that, Your Honor. The only question I have, Mr. Elhart, as part of the agreement, his client was going to sign a quitclaim deed to any interest she may have in the house that Nick owned prior to their marriage. Has that been executed as well?
Your Honor, I'll address the court. The answer to that is she has no interest in the home. As you're well aware, dower interest is terminated a number of years ago, so she has no interest in the home. We have no objection to signing quitclaim deed, but it has no use.
Okay. Mr. Isles, I don't know how you want to proceed. I mean, if that's a condition of us proceeding today, or if that's something that you want to work out with Mr.
You know what? Quite frankly, I know Mr. Elhart's reputation, and I know Clara well. Nick is my nephew. So I have complete confidence that they will sign the quitclaim deed. I just feel that it would be better to have it filed in the chain of title so there's no possible issues in terms of clouds in the future. So we can deal with that later. Let's go forward and place this on the record.
All right, Mr. Ernst and Ms. Ernst, I'm going to need both of you to unmute at this time, please. Okay, and if you can both raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can both lower your hands. Mr. Elhart, if you'd like to proceed with the examination of your client, please.
Thank you very much. Ms. Ernst, would you kindly state your name for the record?
Nicholas Paul Ernst. Oh, sorry.
That's
Sorry,
Ms., not Mr. Ms.
Clara Ernst.
Thank you. Ms. Ernst, you filed a complaint for divorce, indicating within that complaint for divorce that you were married to a Nick Ernst. Is that accurate?
Yes.
It further indicates that you have no children born of that marriage. Is that correct?
Yes.
It further indicates that you're not now pregnant. Is that accurate?
Yes.
Thank you. Lastly, it indicates that there's been a breakdown of the marriage relationship to the extent the objects of matrimony are no longer possible, and that there remains no reasonable likelihood the marriage can be preserved. If the judge were to put the two of you to counseling today, do you think you could save the marriage?
No.
Are you asking the judge to dissolve the marriage?
Yes.
It's a very short-term marriage in many respects, but at the end of the day, the two of you really obtained nothing during the course of your marriage. Is that true?
Yes.
And it further indicated that you've divided the personal property that the two of you had, and I understand that you vacated the marital home. Is that true?
Yes.
You claim no interest in the marital home, do you?
No.
All right. And you have your motor vehicle, despite the fact that it needs coolant on a regular basis.
Yes.
All right. Thank you, Your Honor. I have no further questions of the witness.
Mr. Isles, did you have any questions for Ms. Ernst?
I do not.
Did you wish to question your client?
If I may.
Please proceed.
Nick, you heard everything that was asked on the record today?
Yes.
And you agree and you wish to have the marriage dissolved at this time?
Yes.
Nothing further, Your Honor. Thank you.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. The court will grant the divorce. Once that judgment's presented to the court for signature, the court will sign that. Mr. Elhart, anything else I can address for your side today?
Thank you. No, Your Honor. Have a safe day all.
Thank you. Mr. Isles?
No, Your Honor. Thank you.
All right, that's all for this hearing. All parties on this file are free to disconnect. Thank you. Okay, just waiting for one, there we go, there's Ms. Beach. All right, great. Okay, we'll go on the record in Nellis versus Munson, file number 21-13787. If I could have counsel starting with plaintiff, put your appearances on the records, please.
Good afternoon, Your Honor. John Elliott on behalf of Mr. Nellis.
Good afternoon, Your Honor. Nick Arteev on behalf of the Kalkaska defendants.
Good afternoon, Your Honor. Karen Beach on behalf of defendant Munson.
All right, thank you. We're on the record today for all defendants' motion to adjourn trial pending their leave to appeal. I did have a chance to review the written submissions by all the parties prior to the hearing today, including plaintiff's response. So with that, Mr. Arteev or Ms. Beach, whoever wants to go first, please proceed with your argument.
Thank you, Your Honor. I really don't have much to add other than what's with our brief. I think, quite frankly, it's procedurally, it just doesn't really make much sense to go forward with the trial as scheduled right now. Based on our current wait times, we understand the Court of Appeals is taking about 5 months to even decide whether they want to take on an application for leave to appeal. We actually just had one case that was filed in April, I think one in April 15th and another in April 29th, pretty much 5 months to the date came back with decisions. And so that would put us, based on when we filed our leave to appeal on September 11th, 2025, that'd be about 5 months from that date. So that puts us in February. And as we mentioned in our briefing, there's the issues we're appealing, I think, directly impact the scope of trial and the types of witnesses that are going to be called. So, and on top of that, the types of motions in limine we're contemplating on filing. So I think it going forward and going forward with a trial while there's a pending potential appeal on these relevant issues, just I don't think it would make much sense. I think it would be burdensome. It would be impractical and quite frankly would just increase costs and inconvenience to all the parties here.
Thank you. Ms. Beach, anything you wanted to add to that?
Thank you, Judge. Nothing to add substantively, but I did have a conversation with trial counsel, Mr. Dwahey, this morning, and he informed me that he does have 2 trials already scheduled for that early December period, one which starts on December 8th and one which starts on December 15th. So for that additional reason, a stay is most likely appropriate while the appeal is pending.
Thank you. Mr. Elliott.
Your Honor, I disagree that a stay is appropriate here. And again, I won't get too much into my brief, but an appeal is always possible. The defendants chose to wait to the last possible minute to file the application. They chose to wait to file this motion to stay 2 weeks after knowing that it would not be stipulated to. This is a straightforward trial. The issues that are raised on appeal, just like any time, are relevant to trial. But the fact of the matter is we've went through 4 years of briefing and litigating this case. Your Honor made decisions throughout that time on various motions, and we've whittled it down and we're prepared to go to trial as scheduled at this time. I'd ask Your Honor to deny the motion to stay. As Your Honor, I'm sure, as brother and sister counsel are aware, the percentages of the applications are even taken, let alone granted, are very low. So there's a very good chance we would be delaying this case as this gentleman turns 80 years old, waiting for his day in court, to never even have this even looked at by the Court of Appeals, much less decided at this time, as opposed to the appeal that the defense, I think, already point out in their motion they're planning on taking the option to take after the trial. I'd ask Your Honor to keep this matter scheduled. As far as the alleged conflict, I looked to the other courts and I already addressed that. I think this court should take precedence over that anyways, for the reasons addressed in my objection to the trial conflict notice that was filed previously. Your Honor, I'd ask that you keep us on the docket for December 15th. we have that week set aside. Your Honor has that week available. We can try this case. And if the defendants want to appeal afterwards, they can appeal it afterwards. But I think it's time to get on with this.
Thank you. Mr. Arteaga or Ms. Beach, it's defendant's motion. I'll give you the last word. Anything that you want to, either of you want to say in response?
And no, Your Honor, I think again, I know plaintiff's counsel disagrees with our appeal and is disagrees with the merits of our appeal, but quite frankly, I don't think that matters procedurally. The issues that are being decided on the leave of the appeal, we've exercised our right on behalf of our client as to appeal these issues at this time, and ask for an interlocutory appeal. Those issues that are going to be decided directly affect what's going to be discussed at trial. Specifically, this case could be dismissed in its entirety and we don't even need a trial by the Court of Appeals. And then the other part to it too is that there's a defendant who may be dismissed in his entirety, and then there's very significant damages that plaintiffs are claiming that could be stricken that require expert witnesses to be prepared. So I don't think it makes sense again to go forward with a full trial and then out with the possibility of the Court of Appeals out there going forward and reviewing those issues that kind of set the scope of what the trial should be about. Thank you.
Thank you. Ms. Beach, anything further from your side?
No, thank you.
Okay. Again, I did have a chance to review the written submissions, which are consistent with the arguments of counsel here for the record today. First of all, the standard the court's looking at is a discretionary decision whether or not to grant a continuance or adjourn trial dates is something that's within the discretion of the trial court, and the court's acting within its discretion in deciding the motion here today. First of all, the court finds that any conflict that Mr. Dwayhe may have, given his firm, given that the trial dates aren't until December, it's the court's view that either another attorney can be more than prepared to address trial in this matter from that firm. Numerous attorneys from that firm, or several attorneys from that firm, have made appearances in this case and argued motions and so forth. So Mr. Dwayhe isn't the only one who's familiar with the file, and there's sufficient time for an attorney from that firm, 4 months, and to be prepared and ready to go for trial in this case. So the court finds within the exercise of its discretion that that is not a reason to adjourn the trial date. With regard to more of the substance, I guess, of the motion, the court finds that seeking an appeal of a ruling on a motion for summary disposition is not an adequate basis to adjourn a trial date. I mean, frankly, if we waited to exhaust appellate rights on every ruling on a motion for summary disposition, even fewer civil cases than already go to trial would go to trial, and wouldn't do so for many years. Parties frequently challenge rulings on motions for summary disposition as part of post-trial appeals. In my view, that's the appropriate time and place for that, rather than through an interlocutory appeal, and certainly one that would result in a delay of a case that was originated in 2021 and has already been pending for 4 years. I also would note, as we've discussed at previous hearings, or plaintiff has at least, the plaintiff in this case, Mr. Nellis, is elderly, and the court finds that his situation in particular works against granting further adjournments or further delays in the case. So again, in the exercise of the court's discretion, it finds that seeking leave to appeal a ruling on a motion for summary disposition in a case that's 4 years old with an elderly plaintiff is not an adequate basis to adjourn the trial, certainly not for another 5 or 6 months or however long it may take to get a ruling on an application for leave. So for those reasons, the court will deny the motion. Mr. Arteaga, as the moving party, I'll just request that you prepare an order reflecting the ruling of the court today and submit that under the 7-day rule. And that's all I have for today. Mr. Arteaga or Ms. Beach, anything further from defendants?
No, Your Honor, that's fine. Thank you.
Nothing further, Your Honor. Thank you.
All right, thank you, Mr. Elliott.
No, thank you, Your Honor.
Okay, thank you. That's all for today. All parties on this file are free to disconnect.
Thanks.
That concludes the court's afternoon.